Today it changed from dismissal, which was what I was prepared and what I'm arguing about, to, well, no, it's just you have to give them 40 to 60. The statute says once we file the motion, you have to have a hearing. There's nothing that precludes or prohibits you in doing that hearing to say and make an inference that, well, I'm going to give a term of years because I'm missing information. But you still have to have that hearing and make a determination after that hearing. We file the motion, you need the hearing, and if you want to incorporate the lack of file and missing some information into your findings as to why you're going to give them a term of years instead of life in prison, that's your prerogative. There's nothing that prohibits you from doing something like that. But the law clearly states that you have to have the sentencing hearing. So it's time to move forward to start working towards the sentencing hearing instead of dealing with these appellate motions that we're not here to do. We're here to resentence Mr. Lewis.
All right.
Brief response.
Yes.
Your Honor, in the Groundhog's movie, Bill Murray every day got up and got it wrong. The day was a disaster. But one day he got it right. He got it right in the end. The problem is we haven't gotten it right. That file from 2 years ago isn't right. So we are in this perpetual problem that hasn't been resolved. Bill Murray got it right in the end. Complete file was Bill Murray's, in our analogy, would have been the end game. Here we don't. And while the government points out the other Miller factors, you have to remember, Mr. Lewis's cert was granted by the U.S. Supreme Court. This is a remand, and one of the factors the court has to look at, not the only factor, but I think the key factor, and a factor that directly affects this issue, is that the nature and circumstances of the case. So if that factor can't be fairly addressed, you can't really look at the testimony. In fact, while we skirt over things, we accentuate other things, the issue here is whether the first trial transcripts is complete, that's important, whether there's records from why that jury was dismissed, and then you have important issues like whether there was agreements with these juveniles and motives to lie and those kind of things. The court can't see all that. Then it's true, this perpetual Groundhog's Day will continue, and the court has to make a determination whether in a vacuum, the court can just come up with assumptions, come up with filler of things that don't exist. And the 2 years has been their opportunity, and perhaps the court's opportunity and the administrator's opportunity to get it right. So while Groundhog's Day continues, we can't get it right. The only remedy is to make sure that we don't get it wrong.
I just have one point that I forgot to mention. We brought it up. The agreements with the juveniles are in the transcript. They are in the transcript, and the agreement was that if they were to be prosecuted, it would be prosecuted in juvenile. They were asked that on the stand, and they said that on the record.
It's your motion, Mr. Schulman. You have the last word. Is there anything else you want to say?
No, you're right. I'll just rely on my brief motion.
All right. And you want to address the motion for bond pending resentencing?
I'll leave that to the court's discussion.
Okay. All right. First, I'm going to...
Yeah, I'd like to object to Mr. Dawson's, whatever it was he said. I'd like to object to that. And I think as a judge, I think the one thing that I would like for you to consider when you make a decision on this is whether or not the first jury was improperly dismissed. Because if the first jury was improperly dismissed, then that means that everything that came after that is really irrelevant. And in People versus Benton, 402 Mish at page 47, that case pretty much says if there's no specified reason on the record for why the jury was dismissed, then that's the equivalent of an acquittal. But that's what the law says. So, I'm asking you to evaluate that when you make your decision. He talked about People versus Pearson, but People versus Pearson is real clear. The law of People versus Pearson still exists today. If you have a Pearson hearing, the prosecutor got 30 days to hold a hearing. After 30 days, the conviction is automatically vacated. System failed me. The system failed me when the first jury was improperly dismissed. It failed. The system failed me when the second jury was improperly dismissed on May 23rd. The system failed when the third jury was impaneled, and there's no record of whether it was 12 white jurors, 12 black jurors,